And Miss Alexander, how are you?
How are you?
This case will be administratively closed. Then I'll grant a judgment. You didn't assert or some misunderstanding of the judgment itself. You have the right to file a motion within that time frame to set this aside. That doesn't mean that I will, but you have the right to do that.
Okay,
Understand that?
sir.
Any other questions about that?
No, sir.
All right. I will grant a judgment by consent as to defendant 2, by default as to defendant 1 along the same terms, consistent with the terms that are placed on the record. All right. Thank you.
Okay.
All right. You're all set. You have a great weekend.
As well, thank you.
Northville Crossing versus Ardell Carson. Did somebody? Whoa. Somebody else wants it.
How are you doing, Your Honor?
I'm doing well. How are you? Of
Good, doing fantastic. You have a great holiday?
course. Always do.
Awesome.
Power went out, but whatever. All right. How much is owing?
With cost $1,048.34.
All right. How are we gonna get this paid?
We just got approved from Hawk. They said that it will help us with our payment. I just received an email from my caseworker yesterday. And they said that they will let me know by Monday what funds they have available, and we'll be able to take it from there.
They'll let you know on Monday what form. So it's an approval by Hawk?
I just got the email yesterday.
I have nothing, right? From them. And
You do not, no.
when did you get this email?
I got it yesterday.
Yesterday, saying that you've been approved and no.
Mhm.
All right.
Her name is Autumn Order.
From Autumn. Okay. What I'm inclined to do is set it over a week, see what's there. They send us a list, but she's
Okay.
not on it, but I believe.
Correct. I just
Sure.
got approved that. Yeah, just got the email yesterday.
So I'll adjourn it out to July 17, 2026 at 1 p.m.
Okay.
Okay?
All right.
Yep. Have a great weekend.
All right. You too, sir. Thank you so much.
Northville Crossing versus Jelene Davis. She's in Zoom.
Got approved that. Yeah, just got the email yesterday.
So I'll adjourn it out to July 17, 2026 at 1 p.m.
Okay.
Okay?
All right.
Yep. Have a great weekend.
All right. You too, sir. Thank you so much.
Northville Crossing versus Jelene Davis. She's in Zoom. Is that your understanding, Ms. Davis?
Yes.
Okay. If that were entered in the form of a consent judgment, do you have any questions regarding that judgment?
No.
All right. And
I've been listening to my wife.
this is Miss Davis, so I would enter consent defendant 1 by default along the same terms as to defendant 2. All right. And so, Ms. Davis, as long as the judgment comports with what's been placed on the record here, do you have a problem allowing Ms. Dornbush to sign your name to that?
No, I do not.
All right. And I would advise you that you have 3 business days from the time that I signed the judgment, okay? You have 3 business days to think about it. There's a right you didn't assert, some confusion on your part or something you misunderstood. You could file a motion with the court within that time frame. Doesn't mean that I would set it aside, but certainly you have that right to file that motion to set that aside. You understand that?
Yes.
All right, fantastic. And what I'll do is I'll grant a judgment for possession by consent, 183441 plus August. It will be included in this, and a payment plan is included with that. That is by default as to defendant 2, by consent as to defendant 1.
Okay.
All right.
Thank you. Your
Thank
Honor.
you.
Thank you.
Take care.
Finally got my husband to listen to me.
Pardon?
I finally got my husband to listen to me.
Finally?
Yes.
What's his problem? Why wasn't he listening to you before?
He's just stupid.
All right, fair enough.
Remind him who I was.
Right.
I was always talking. Wouldn't let you talk.
Well, he talking on the phone now, so yeah.
Okay. All right, ma'am. You take care. You have a great weekend.
You as well. Thank you.
And show him some patience. He can't help it. It's just our gender. Northville Crossing versus Tony Rogers.
Not sure.
Tony Rogers, they are not here. You've previously been sworn. You may proceed.
Well, Your Honor, my client did reach terms for a proposed consent judgment with Ms. Rogers as well. I'll put the terms on the record, Your Honor, and then I don't know if the court would allow me to just submit that under the 7-day rule, or if you want to enter it as a default. It does, though, include the August charges, and so I'll let you know what it is. So we've got a current balance of $1,851. That balance plus the August charges. The agreement was a payment on 7/14 for $713, a payment on 7/28 for $713, a payment on August 11th for $713, and then on August 25th, any remaining balance. If the court is comfortable with it, I would propose submitting that under the 7-day rule as a consent.
Yeah. All right. And that's fine. It's just submit that under the 7-day rule. Allow her an opportunity to object. No objection, we'll sign off.
Very good, Your Honor. Thank you. Thank you.
Northville Crossing versus Cassandra Studer. And Cheryl Richter. Hello,
Hi there,
your name?
Cheryl Richter.
All right. And where are we on this case?
With cost $3,098.11.
All right. And ma'am, how are you gonna get that?
So I thought that I would be able to do that, but we had a bit of trouble with our only vehicle in our household, engine blowing up after getting repairs. Up. So I reached out to the Housing Bureau for Seniors, and they agreed to help us with anything that we couldn't come up with.
Pardon?
With anything that we couldn't come up.
Okay. When did they say that they would be doing that?
When they contacted me this morning, I submitted all of the documentation that they needed, paycheck stub, proof of income.
Here's what I'm gonna do in this case. I'm gonna grant the judgment, and I think Housing Bureau for Seniors will help you, okay? But I'm gonna find no tribal issue after hearing as to defendant 2. I'll order it by default as to defendant 1 for the total amount of the $3,098.11, which is inclusive of cost. I would extend the writ date out, and so that you know, ma'am, to let Housing Bureau for Seniors know, the writ would issue the 24th.
That is
Oh.
3,100, okay.
Okay, and that's what you're gonna need, and that you have to have that by the 24th of this month
Okay, to Northville Crossing or here.
to Northville
Okay.
Crossing. Okay. Jelene Meadows versus Byron Terraza.
Neither checked them.
And Jasmine Harris. Either
For a total redemptive amount $2,359 to be paid on or before October 27th, 2025. That amount was not paid. An order of eviction was subsequently requested, issued, and executed. Your Honor, the mobile home at issue has been abandoned by the title holder. The sole title holder for the home is a Byron Terraza. Ms. Harris point regarding that process. Since the home still resides on my client's property, the current balance owed is $6,918. We would request that the court deem this home abandoned and award title to Celine Meadows.
All right. Based on that allocation, the court will grant the plaintiff's order, grant the plaintiff's motion, and will sign the order allowing the disposition of the mobile home. And it's the one that you had submitted to the court, and I have signed it.
Thank you, Your Honor. And just for the record, I would indicate that we did serve Jose Terraza with a copy of this motion at the email address that we had previously been corresponding with him through, as well as, oddly enough, an address that a postal verification indicated that Byron Terraza was receiving mail at. So I don't know if, you know, he's got some friends or family here who's collecting his mail, but we did serve it there as well.
I got you. Okay, fantastic.
Thank you.
Scio Farms versus Paula Clark. Oh,
Here.
there they are. Paula Clark and Anthony Clark.
Good afternoon.
Good afternoon. All right. And where are we on this case?
Your Honor, the University of Michigan, I think it's the SKIP program, the Senior Services Program, had emailed my client indicating that they were going to assist with $2,529.58 that they anticipated hand delivering this past Wednesday, but they say they always give themselves 2 weeks, so they're saying no later than July 15th.
Okay.
Right now, I've got a balance due of $25.94.38, which will leave just a small portion for defendants to otherwise pay. $64.80 would be the difference. Your Honor, today is the sixth hearing on this. What I would propose, if the court is in agreement, is that the court take a judgment under advisement. If that payment is not received as promised by the University of Michigan by the 15th.
Oh, we got somebody here screaming at me. Hold on. No, come on up to the podium. State your name.
Madden Linton Housing Bureau for Seniors. So that was delivered Wednesday. So no worries. It was
Who
delivered.
was it
hold on.
delivered to? It said it was delivered to Scio. Do you know who you gave it to over there?
I don't.
Client. And then
That's
before
fine.
we talking about that $65.
Before
Yes.
we do that, Judge Simpson, hi, this is Alicia. My mom's at work. Anthony's right here.
Okay.
Really quick. So we logged in and it definitely it shows the minimum due is $64.80. So it was credited when she took it in. I know Rachel Ms. Dornbush is going to check in, make sure, but we can log in and see it right now. I have two questions though. Well, yeah. So the check for the money order for $974 was for July 5th, and it was in the box before the office opened on July 6th because they were closed on Friday the 3rd, as well as, of course, the holiday, and then the 5th was on a Sunday. They charged, as soon as the office opened, before posting the check, a $55 late fee. And it's always been rule of thumb that. Go ahead, sorry. And Madden,
Okay. If
I
the
talked to
check
her.
got there, hold
Sorry.
on. If the check got there on Wednesday, would they have been charged that?
Yes,
amount?
late fees, Your Honor, are charged after the 5th. So it charged properly on July 6th.
Got it. And the check didn't get there till the 8th.
Yes, I did ask though if the late fee was for my amount because I sent a commitment weeks ago, well, like shortly after the last hearing. And so they said it was likely because of the June. Keep in mind, the client doesn't get a social security check till the 3rd, so he can't pay the rent till the 3rd. So he had to.
I get all of that. Thank you.
So they weren't willing to
All
pay,
right.
a lot of people are.
Okay, so what I'm gonna do is let me pass it, figure it out. Since it sounds to me like the late fee was properly charged, but we'll figure out how we're gonna work that out. Clark
Okay.
and Anthony, she doesn't let Anthony talk. That's
No.
okay. No, don't
I'm
let him
sorry.
talk. No,
I
don't
do,
let him
but
talk. You are doing just fine. He
Well,
started
my-
talking every.
well, my daddy said that if I didn't attend this, I started a new job, Judge Simpson, and I was at work. I had to leave. My daddy said that if I did not come and be present with my brother, he was going to revoke my authority with helping him. And I said, absolutely not. So
Wow.
I had to make
Wow.
sure that I came and I did exactly what I was asked. So, and I'm asking.
Right, I got a tough family. All right.
little bit.
Okay.
But so you want us just to stay on here and just wait, right?
Yes, just stay on and we'll see if we can get an answer real quick for you guys, okay?
Okay, thank you.
Set it aside.
First of all, I was on the phone with Zoom. The reason why I got defaulted, but you didn't hear me. And prior to being on hold, waiting for my name to be called, I had called Jeannie to let her know the dates and stuff like that, what I was going to pay. But apparently she didn't speak up for me and let you know that I was on the phone, so you called it. But I still didn't have the amount of money to pay. So now it came to a 3-day notice. They end up locking me out, I don't know, for like a week and a half now. When they told me the 3-day notice, I called and we asked what if they put my stuff on the streets. And she said no, because it was different situation because I own the trailer. That I had 45 days to pay or move. She said, no, you have to move or sell your trailer. And I about freaked because that's my home. I've been there 13 years. And so long story short, I'm trying to get it dismissed. I have $1,800. That's including the $600 I paid when I filed for the motion. I have to actually 400. I have 800 now, but I have 400 that I can do a debit or go straight to the bank and bring the other 400 back. Plus I paid the 600 to the court when I filed the motion. And I'm asking to try to get back in my home because if you grant this and I give you the 1,800, I have no money left to say yours. So I'm on Social Security now. I get my Social Security check on Wednesday. Well, they say the third Wednesday of every month, but it's been coming on a Monday, 2 days before. So I'm asking to get till next Friday to pay the balance, which Madden is going to help me with some, and then I'll have the balance by next Friday. But if I can't get back into my home, I have no place to stay if I give you what money I have now.
Week. And so it wasn't a timely filed motion to
Correct.
begin with. Additionally, as Ms. Cornett indicated, they've already executed the order of eviction. The 45-day time frame that Ms. Cornett is referring to is not pertaining to her occupancy of the home. It's pertaining to her disposition of the home on the site since she owns
But when
the
I
home.
call them,
Ma'am, please, go ahead, Ms. Stormbush.
Your Honor, my client is not in agreement with reestablishing a tenancy with Ms. Cornett. I would also add, Your Honor, that after the order of eviction was executed, Ms. Cornett was found breaking into the home so she could cook a meal there. The police were called and the home had to be resecured at that point. So unfortunately, Your Honor, my client is not willing, they're not interested in reestablishing a tenancy with Ms. Cornett.
never done anything wrong there. Yes, I went in the home, but my back window is a plexiglass and I needed more dog food because when they came and locked me out, I had my grandson and a dog to deal with, and they gave me 20 minutes to get all my stuff together. They were supposed to come on a Monday. I had all my refrigerator, my freezer stuff, my clothes packed. When they didn't come, I thought Jeannie maybe I had the 45 days. Then they came on Thursday at 10:30 in the morning, and I had my grandson and my dog, and I was trying to gather everything, and I had not gotten dog food. So yes, I was wrong, but I have never done anything wrong there besides not paying my rent on time or my grass not being cut. I have also not volunteered, but told them that with my social security now that I'm gonna do automatic payments for my rent, so this will never happen again.
The
There-
other thing, Your Honor, and the other reason why, I mean, part of the reason is after being evicted, Miss Cornett moved into the home across the street as an unauthorized occupant.
They never told me I couldn't. They never said, and everyone there knew I was there. They never come to me and said, Cheryl, you have to leave. So that's not my fault. They never came there. All the maintenance guys, Jeannie, Andrea, they all knew I was there.
That home was subsequently evicted, Your Honor, due to, there was a pending non-payment case in that case as well. And so the problem resolved itself through the eviction that was pending in that case.
Okay. The motion to set aside either the writ or the judgment in this case, given all of the circumstances, the court is going to deny that motion. The writ and the execution of that writ will stand. The disposition of the $600, which is paid over, there's still a back balance owed.
At present, Your Honor, the balance is $3,733.31.
So,
Your Honor,
and
I
then
think
you're checking on the
Oh,
clock.
the other one, yes, and I'm so sorry, Your Honor. I literally just got a text message from my client confirming, yes, they did receive the payment on July 8th, confirming the remaining balance of the $64.80. Your Honor, I'm not inclined to take a judgment over the $64.80. I don't have any authority to waive it. If they talk to Patty in the office and Patty's agreeable to it, then so be it. If she's not, then they would just need to pay that
All right,
whenever.
Ms. Clark?
Yes, sorry.
All right, there you are. That's okay. So there's $64 owed. They did confirm the payment.
Oh, sorry.
John, you're gonna keep talking and then bad things happen. Right now, I'm about to have maybe a good thing happen. We'll see.
Okay.
Okay,
Mhm.
but the money was coming from there. I think everybody was acting in good faith to try to do that, and the money was received and everything. The court, on its own motion, is gonna waive the $64. I'm just gonna waive that. If the plaintiff doesn't like it, then appeal me. Uh-oh. This group looks like they're gonna cause a problem. Mr. Allen, stay close. All right. Court's in recess. All right. Yes.
All right, we're gonna get you guys checked in for the 1 o'clock slot. Jermaine Banjum, are you here? Thank you. Christopher Hesterly?
You may be seated. Courthouse case of Evergreen Apartments versus Jermaine Madden.
Good afternoon, you're in for pleaser.
Jermaine Madden. All right. And where are we on this case?
I have the amount remaining on the judgment is $1,845.82. Mr. Mangum's current balance is almost $4,000. It's $3,959. And so at this time, Your Honor, plaintiff is requesting that the court.
Sir?
Y'all didn't get that payment? Y'all didn't get that $2,000 payment?
Or how much was it?
2,000.
When was that made?
It was made today. I supposed to pay 1,000 last time I was here, and then paid 1,000 today. But I ain't paid all until I ain't paid till.
In what?
Remember, I supposed to pay 1,000 last time I was here, and then paid another 1,000 today. So I ain't paid the last 1,000 because I had the money, but I was trying to like get more money up type of thing. So I ain't paid the 1,000 until today.
I see confirmation that the payment was made today.
2,000
Paying off the judgment.
paid off the judgment. All right. I'm gonna indicate, judgment has been satisfied. That doesn't mean that you have a zero balance. You understand that, sir?
Yeah, I understand it.
So if you're gonna catch that up, they'll probably just refile and then be back here.
Yeah, I'm gonna just.
All right?
Yeah, yeah.
But I'd suggest you get yourself caught up so you don't come back. All right. Evergreen versus Christopher Hesterly. Christopher without a T.
Jelene.
Not.
Your Honor, this is a case for non-payment of rent. Rent to retain possession is $4,068.95. Court costs are $172.
Evergreen Apartments versus Madison Haynes.
Jelene for
And Ashton Mathis. All right.
Like 28.
Right.
I made up 2,650 last night. Get that caught up. The remaining
You made a payment of how much?
2,650.
Is that what brought it down to the 1415? Because when I look at my June numbers, I don't know if that. Oh, maybe it does. And that was last night you did that?
I see that payment, $2,650.
And so that's been included in the figure?
Yes.
Okay, all right.
The remaining of what I owe is from this current month that we're in currently.
Right. So how are you gonna get that paid?
I'm just working.
No, I know. I guess I'll ask it this way. When will you get it paid?
It will be paid before my lease ends on August 2nd.
Okay, so here's the problem. The problem is I can't give you if I were to give them a judgment today, you would have to pay it by the 20th.
Your Honor, I could stipulate to extend that to August 2nd.
You can? All right. So here's what I'll do, young man. If I'm gonna find no tribal issue after hearing, I'm gonna grant a judgment for the 14-15-92. 31st, 2026. There's gonna be a 72-hour period anyway by the time they get it to me, so you'll be good. Okay?
Sounds good.
All right. Take care of yourself. Thank you. Calls the case Dunco Hills versus Dana Williams.
Hello.
Oh, there she is.
Hey.
Who you are?
Oh, you said who's
Yes.
that? It's not my mom.
Brushing the podium. Don't worry about it.
Oh.
All right. Yes, and Jacqueline Murphy. All right. So where are we on this case?
I have a balance including court costs of $2,116.28.
Did you get the payment earlier today?
Let me check.
How much was the payment today?
1,400 or 1,450. I'm unsure. I can check though.
I have a payment for 1,400 from this morning.
Okay.
And so it's already been taken off on this figure.
Yes.
Okay. Yeah.
Is that 2,000? I can get it paid by the. One moment. Sorry, my son was talking to me. I can get it paid. I can get all of July paid by. I know you said like the 20th was the latest that you could do for a writ, but I get paid on the 24th.
Yeah.
Okay.
We can work with that. So you think you can get this whole balance in by the end of the month?
You said 2,000 something? Yes.
$2,116.
2116, yeah.
Is that a yes?
Yes.
Oh, okay. I didn't know if you were talking to me or your son.
No, he
Anyway,
walked
no,
away.
I'm kidding. I'm kidding. I'm gonna find no tribal issue after a hearing. I'm gonna grant a judgment to the plaintiff
Thank you.
for the 2116. That's a judgment for possession, and then with a writ to issue July 31st, 2026.
You know what? Let me do this. There was it one.
If you got to the end of the month, get this all cleared up, okay?
Thank you.
Thank you. You have a great weekend.
You too.
Glencoe Hills versus Cathy Ann Haynes
Again for plain.
and Anthony Haynes.
I have a balance in court for July rent of $1,903.61.
Okay. All right. How are you gonna get this paid?
I can do 1,500 on next Friday
17th,
and
okay.
balance by the end of the month if I could.
Okay. What I'll do is I'll find no tribal issue after hearing in this case. Judgment for possession for the 190361 with a writ to issue July 31st. All right. So get that one payment that you're gonna make on the 17th in, and then you'll have to the end of the month. Glencoe Hills versus Miguel Lopez.
Julian Engen for plaintiff.
Oh, Miguel Lopez. You're Samuel?
Yeah.
Okay. All right, this is your motion to set aside the judgment. The judgment was entered.
So I have a current balance including court costs of $4,868.11. I don't see that any payments have been made since May. For April.
Sure how this got on because I don't even have a bond posted. What's your basis why you want this stayed or set aside, sir?
I actually just heard that it could keep like an eviction off your record or something like that.
No.
But I'm not sure at this point because they just had me re-sign my lease like last week or the week before.
Really?
Your Honor, I don't have any knowledge of that, but
Got
I
it.
know that the amount is still owing.
All right, so you better clarify things with your landlord. I'm gonna. Glencoe Hills versus Willie Williams.
Julian,
Your name? Willie Williams. All right.
including court costs of $2,408.38.
Okay, I had completed the state emergency thing. I just got that back today. And I was denied. They have been working with Friends Indeed. So I'm gonna ask for a little more time until
I'm gonna find no tribal issue after hearing judgment for 240834. Glencoe Hills versus Andrew Jacobson. Glencoe Oaks versus Ronell Hodges.
Only with a written issue after 10 days.
Judgment to the plaintiff, that is by default for possession. Redemption amount in the amount requested with a writ issue in 10 days. Foreman.
Again for plaintiff.
Foreman's. No response, you may proceed.
Thank you, Your Honor. This is the case for non-payment of rent. Rent retained possession is $6,970.42. Court costs are $212 for a total of $7,182.42. Plaintiff requests a reasonable judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff that is by default for possession and redemption amount is in the amount requested.
Writ to issue after 10 days.
Judgment to the plaintiff that is by default for possession and redemption amount is in the amount requested. Writ to issue in 10 days. Gulfside Lake 1 and 2 versus Shetia Brown. Hello. Your name?
Tia,
All right.
the one you forgot last time.
Come on, I finally. Yeah. That's that. Yeah, it was just so she can come at me. All right.
I have a balance including court costs of $1,610.33.
Yeah, I paid 22.
July red kid. All right.
And I'm moving next week, but I just paid $600 today.
Okay, when are you moving?
Next week.
Next week?
Mm-hmm.
If it's
What-
before Friday, I'm happy to adjourn.
Yeah. Are you gonna move before Friday the 17th?
What you mean, adjourn? Like, what we doing?
Like put the case over to next week, and if you've moved out and turned in your keys, then we'll dismiss.
Oh.
So you out before then? And
Before Friday?
or Friday? You next week?
Yeah, and then I ain't gotta pay nothing. I ain't gonna have nothing.
That's not true. You
No.
still owe the balance, but they can do a payment plan with you.
Okay.
For the balance. And the earlier you move, the less you'll actually owe, because generally they prorate your rent. Based on your move out date.
Because I only owe like 1,010, so you saying
Right. So then what will happen, but that 1,010
Mhm.
includes all of
the rest of
July.
July, yeah.
And what she's indicating is that the earlier that you move out, they'll prorate it.
So to go down a little bit.
Yeah, it's gonna go down for you.
They are going to add on utilities in arrears, so
I just don't want no evictions on my stuff.
so if you move out and we dismiss it, then it'll just show if someone looks it up that it ended in a dismissal, not a judgment,
Okay, so before
Friday. And make sure you turn in your key
Can
in
it
the
be-
office
oh well, you're saying like
So what I will do is
Friday morning.
I'll adjourn it out to July 17th, 2 p.m.
I didn't hear you.
I think you're just gonna come back here to just treat me bad.
No.
Okay, no, that's it. I know, I get it.
Okay.
What happens if you move out? They're gonna dismiss it. You turn in your keys and make sure everything's all set. They're gonna dismiss it, so you won't have to come back.
Good. Yes.
Wow, come back good.
I'm happy.
Thank how I saw it.
Thank you.
You're welcome. Have a great weekend. Gulfside Lake 1 and 2 versus Marcus Baskin. Your name?
Marcus Baskin.
All right. And also Taylor Jackson.
She wasn't able to be here with us. She with our children.
Okay. How much is owing?
I have a balance including court costs of $2,666.
Here with us. She with our children.
Okay. How much is owing?
I have a balance including court costs of $2,666.
A little bit behind from when we were in June. When can you get that paid off?
I made a payment of I was ordered to pay $750 by on or before today. I made that this morning around 7, 8, or 9 a.m.
You made the $750?
Yes.
Okay, right. And so you're around the 1,900. So when can you get that paid?
Roughly within the middle of August, toward the end. We had just got done moving. We just had to move out by the 1st. Yeah, we in the process of getting everything out of there already now.
So you'll be moving before.
I did all the lifting and moving already. I had to get them out of there so that way we could have to leave it on.
No, I got you. But can you get that done by this Friday?
Yes, definitely.
Then here's what I'm gonna do. I'm gonna put this over to the 17th, just like we were talking about with previous defendant. What time is that?
2 p.m.
2 p.m. on the 7th. Hello,
How are you?
name.
Kirsten Tidwell.
Okay. How about you, Zoe?
I have a balance including court costs of $2,940.
June, and I let you know I would be able to make a $600 payment with my check on the 1st of July. I did make that payment. And then I also applied for the state emergency relief fund, but my application was denied. However, I do have a U-Haul truck outside my apartment right now, so I'm on my way to pack and move after I leave here today.
House.
I did.
Okay, so what I'm gonna do is I'll adjourn this over to the 17th, 2026 at 2 p.m. Get out of there, make sure the keys are in. What will end up happening is they'll dismiss it.
Okay.
They'll likely prorate what you owe for July, work out a payment plan with them to get it paid back and everything. Your name?
William Brinkley.
All right. And sir, what's your position?
They,
Information.
yes, asking for a continuance to try and address my health issues that Mr. Steeman has prevented me from, so I can return back to my profession. This is also, they mentioned the condemned room, and these are the circumstances of the condemned room. Mr. Steeman refused to turn it into insurance to prevent me from the possibility of earning. Brian McCall, who owned Paul Davis Restoration, was there, validated as a valid insurance claim. My mom has been paying bills on an estate that should have been cleared up in 2 years, and none of this would be an issue. But Mr. Steeman was trying to force me out of golf because he thought I hit a golf ball for a living. Also, Your Honor, you note that the house only became livable in May so that I could attain the help to enable back surgery. And I was there as a caretaker to do maintenance and repairs and keep an eye on the property, get help. And Mr. Steeman had prevented me from back surgery for over 20 years, Your Honor, and to use my disabilities against me so that I can't defend myself because of chronic pain that causes amnesia. It's just, I don't believe that's fair.
Well, I just have a termination of tenancy, not
well
necessarily
owes.
You want to keep interrupting me, you can. But where that would have a bearing on his right or the estate's right to terminate your tenancy, or the trust right, I should say.
I have, due to my disabilities, I have not been able to find somebody for legal representation because there are contractors and stuff that have bills due that Mr. Steeman has avoided paying also. So he has a great debt on this property that he avoided paying. When I am left in the country with no phone, no car, and no clothes to perform my profession, things that harmed my back instead of the therapy that helped it. And I'm just asking for a continuance to be able to get the back surgery so I don't have to suffer this.
I'm going to grant judgment to plaintiff for possession. I will extend the redemption time to the 24th.
I'm sorry, sir.
I just issued a judgment for possession. They, instead of it being the 20th, sir, I adjourned it out a week. My file is marked
I have
legal aid, and then you had that week in order to obtain.
I have no, and so just being due to my disabilities, I'm being victimized by being a victim, Your Honor, and I'd just like some legal representation to help defend me.
Have an opportunity. Still contact legal services, but I gave you a week prior to judgment.
Can I get assistance for my disability? Be able to do these things.
I don't know what that
amnesia. I need somebody to help me because
I don't have those services, sir. There are plenty of county agencies that if you're eligible, court does call the case of Evergreen Apartments versus Shonda Richardson.
Oh, I didn't even look if anyone was in Zoom. Do you need the?
Your Honor, this is a non-payment of rent case. The past due rent at this time is $3,182.39. I did see in the notes that the defendant indicated they were going to try to pay in full before today, so I just called the manager about an hour ago, and they haven't made any or tried to.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days. that all you had?
That's all I got.
Okay, have a great weekend. No, that was my bad. No, that was my bad.
Again, P7H209 from the plaintiff. I wish you'd give him Attorney Hall just a little harder time.
I couldn't. It was a default. What was I supposed to do?
Your Honor, at this moment in time, the current balance is 1412 in rent. She had technical difficulties trying to connect, so you set it for today.
All right, Ms. Alledge,
Yeah, I did not know.
how we get? Huh?
I paid 700 today, actually.
Yeah.
Yes.
Okay.
And I also have the Jewish Family Services that's paying 400. So
They're gonna pay for it. Again, do you see the 700 she paid today, or?
Yeah, Your Honor, I do not, but the ledger I have was printed off 2 days ago in preparation for the hearings today. So that could be very well happen. And I have never known her to lie to me, so.
If they pay that, you got 500 you gotta pay.
okay, yes. So and then I know the August is coming up as well. So I have guaranteed income because you know my son, he gets SSI on the 27th. So I'll
The income that you can get this month paid,
yeah,
right?
yes.
Okay, here's what I'm gonna do. I'm gonna find that there's no tribal issue after hearing. I'm gonna grant a judgment for possession. I'm gonna extend the writ date on that. What I'm gonna do is I'm gonna.
Thank you, Your Honor. And Your Honor, I just received a message from my client that unless you put it in the Dropbox, they don't have that payment. So she may want to check with them to see how it got there after the hearing today.
Yeah, it was money order.
Currently, Your Honor, there's 5480 in rent, 240.81 in court fees, for a total of 5720.81. And when we last spoke, she said she's going to try to pay $3,000. I don't see that I've received that.
To 3,000.
Yeah, so I needed to get the balance to the 3, and I told you I get paid today. So well, I'm gonna take the balance to where it's sitting at 3,000.
So you're gonna pay 2,700,
Yeah,
okay?
2 Fridays from the 24th.
Right, I know what you're doing. You're trying, I get you. So what I'm gonna do is I'm gonna find no tribal issue after hearing. I'm gonna grant a judgment for possession for the 542081. And then, so I'm gonna grant that judgment to them, give you to the end of the month to get it clear.
Okay, thank
Fair
you.
enough? All right. Here.
You too.
Thank you, Your Honor.
Here I versus Jasmine Scott. Here.
You too.
Thank you, Your Honor.
Here I versus Jasmine Scott. Come on up, yeah. Everybody else came up. What do you think you're supposed to do? Wait and just yell at me?
No,
that was your.
I'm not gonna do you like old girl. Did you? I promise.
Oh, roll up on me like that.
I'm not gonna. I gonna roll you.
I got Alan. I'm start rolling up like that, and
promise.
oh, roll up on me like that.
I'm not gonna. I gonna roll you.
I got Alan. I'm start rolling up like that, and
Yes, sir.
okay. Where are we now today?
The current balance is 3650 in rent, 239.72 in fees, for a total of 3889. The last time we were here, and we have not. We did see payments from her.
I finally got full-time hours. My check is being exported today, and a woman named Lakeisha Williams at it's like Peace Hub Community Center. She put her hands on it, and she said that her and Washington County were going to be helping me get it all paid down. So I will have the 800 and something as of next week. That check's being exported today. I don't know how the way my job hours anyway, but that check.
After hearing, I'll grant a judgment for possession 388972. I will extend the writ date to July 31st, 2026. Warren, you may proceed.
Thank you, Your Honor. Actually, I was not sworn in this morning, but I will swear they'll tell
You
the truth
don't
to the
swear.
court.
And that's right, you weren't sworn in because you only had one case. You were sloughing off today. No, go ahead.
Now, unlike you, who've done 171 cases today.
Yeah.
And the property has been kept fit for its intended use, so I would move for a default on this matter.
Judgment to the plaintiff by default for possession, redemption amount is in the amount requested with writ issue in 10 days.
Thank you. I'll submit that.
Huron Vista versus Moesha Harrison.
With Hawk, I believe, application was sent. Current balance is 4,460 plus 240.81 in fees for a total of 4700.81. 4700.81.
All right. How are you intending on getting this paid?
With the last court hearing, the attorney that represented them, it was a female, it wasn't him. She, with the nonprofit organization I'm working with, she told us at the court hearing that he has to be on the phone. I've been trying to reach out, get in contact, haven't got no response. I'll talk to her assistant on Monday. Yeah, if they answer the phone.
When you say they, Huron Vista.
The people that represent them.
Oh, so they need.
Yeah.
Your Honor, she's got my phone number. It goes right through. You get to either Samantha or I. We're here every day.
With him, she can't just do it with just him on the phone. So it has to be like a three-way conference call with me then on the phone.
My law firm does not get involved with the payment, Your Honor. That goes directly to the site.
Yeah. So it's going to have to be the site that you're going to have to get in touch with.
So I will have to do it through here on Vista.
It should be you.
And that manager is on the screen right now, Your Honor, if you need to speak with her, Michelle Hauk.
Let's try to get all that arranged with them.
Okay.
I'll give you another week to try to get that arranged.
Okay.
I'm there at 3 p.m. already, Your Honor.
You're there what time?
You had me coming back at 3 p.m. for the morning case from this morning's cases.
Okay. That's at 3 p.m.
I'm sorry, I had to unmute. When was that again? I'm sorry, this is Michelle.
Well, I've been working with my son, and he's a police officer down in Arlington, Texas, and he's been helping me pay it.
Okay.
But what the agreement was, this woman from the Housing Commission, she was supposed to get me in some kind of program where I'll be able to only start paying $300 instead of the $16 where I'm at.
Oh, she's supposed to. Okay. With whom?
Here in Valley Pace. I'm a social worker.
Got it.
She came to visit me once and told me that they're going to do this and the other. Then I haven't heard nothing else from them.
Okay, here's what I'm going to do. Since you got somebody kind of helping you out there, I'm going to adjourn it to the 17th, 2026 at 3 p.m. and let you check into that so we can maybe get a fuller status as to exactly where you are on everything.
Okay.
Okay, fair enough? Yes, sir. Thank you. All right. Court will stand in recess.
All right.
No, she's actually. Okay.
Video now?
Yes, you do.
All right. 14A District Court. This one's with me.
That's with you. Okay. Your name, ma'am?
Because of the condition of this tennis unit, we've gotten multiple complaints from surrounding tenants of the roaches that are coming from this tennis unit. Representative Danbury is here. She has personally inspected this. She indicated to me this is the worst unit she has ever seen. Holes all over the walls, doorknobs barely hanging on, if they're hanging on, litter and garbage strewn throughout the unit. Roach, I don't know if they're droppings or eggs or whatever is throughout. This is the health and safety of other tenants. We have to have this tenant go. The CPS is investigating that it may not be habitable for children in this unit. Bugs.
They told me to skip things.
Okay. Ma'am, what's your position on this?
Your Honor, I do not have a CPS case. That case is closed and it wasn't because of that. That was.
I'm not concerned about the CPS thing.
Okay.
You're not.
I've been working on it. It's just me and his 5 kids and I've been cleaning up. It's no trash or nothing on the floor. I already explained that I was going to repair all the holes that was in the wall and clean the walls off and stuff like that.
Your Honor, my client Willie Williams, there has been some efforts made towards cleaning it.
You're saying that it's not.
My client tells me that she has inspected it personally
but it is impossible for me to determine from the outside of this. I see the photos, but then you tell me that there are certain things that were done. That's the last thing she told me the last time, is that she was something different. And the thing I
That was-
don't know,
And that was repairing the holes and stuff that was in the walls. And my whole strip has bugs. It's not just my house.
I'm gonna need an inspection on the unit before I'm able to rule on this, so. All right, so what I'm gonna do in this case, I'm gonna adjourn this out to the 24th. Linden Square Apartments versus Edward Seaman. Oh, I thought somebody was trying to give you sunglasses.
Good afternoon, Your Honors. Jessica Morris, P 88771, filling in Michael Kern on behalf of Linden Square Splitting.
Your name?
My name is Dale Seaman. My uncle Edward Seaman.
Okay, where are we on this case?
So we had agreed to a consent judgment whereby the tenant agrees to pay the rent to Hayne, $23,198.96 with costs of $255.09 for a total of $23,454.05 with the writ to retain of 20 days, which would make that July 2026 situation, because Dale is Ed's representative and doesn't have such a park. But he has been authorized to make all these transactions. He's been kind of doing all the financial aspects of this case so far. So we would like to defer.
So just some power of attorney over the assets of Edward.
No, we're in the process of getting that taken care of. He lost his wallet when he came to Michigan. So we had at the VA, we had a gentleman draw up
A power of attorney.
and so we just.
So has that been executed by anyone?
I thought it was being executed, but I found out that he's on vacation right now.
It's not because of some guardianship or conservatorship that the power of attorney is necessary. The power of attorney is necessary because he may not have the requisite ID and other stuff to conduct financial transactions. Is that right?
I've been taking care of the rents for quite some number of months. Now he had what he had stolen was his driver's license.
So
And-
we
go
would like to defer to your judgment, given the fact that Mr. Ed Seaman, as of right now, hasn't been able to make any agreements on behalf of.
Edward, are you able to conduct your own affairs? Are you able to conduct your own affairs?
Yes.
You are? Well, if it were $23,050,
But yeah. I think so. I think.
did he get a chance to speak with an attorney regarding this at all?
No.
So there was actually a previous complaint.
Judgment.
And the rent retainment was $45,941.54. They came to an agreement that they would pay a lump sum of $30,000. And for a year after, they would agree to make additional monthly payments of $1,327.13 to make up for the difference. And that additional $1,327 has not been paid monthly.
I understand counsel's concern, and I understand also that I don't know that I would be in a position jurisdictionally to make a determination as to whether or not he could adequately enter into a consent judgment.
May I speak?
Yeah, go ahead.
When he came to Michigan, he was, when he came to Michigan, he lost his wallet
Okay.
and all of his ID. Now,
How long ago was that?
for a while, my brother is one, when he came out here, the assets that he had are in Bank of America,
He being who?
Eddie. And
Okay.
when he didn't have ID, they cut him off. Glenn couldn't get access and I couldn't, so they trying to get ID so that we can keep it back up. Meantime, I've been making all of it. Yes, I'm gonna cover that immediately with my own funding.
So, sir, how soon could you pay to them the $23,050? Oh, no, I get you. I'm just trying to think. You're
We're talking about 20 days by the end of the month. I want to get that. I didn't even know that was open. Is it?
Could you do it by the 24th, about 2 weeks from now? Then what I would do is adjourn this out, let the payment be made, the case would be dismissed. Understanding that you get it paid, it's going to be dismissed in any event, but then the 2350 doesn't reflect then August. I'll adjourn this to the August 7th date. We'll just give a special time for that, okay? You're to make that payment as the agreement basically by the 30th. If you make the agreement by the 30th, that means you're paid up. They'd have to dismiss in any event. If you don't, then you're going to be back on the 7th. We're going to be, and then that way we'll do that. If, and counsel, if for whatever reason things don't work out and we're still in that same boat regarding the consent, probably finding that there's no issue, no genuine issue of material fact, and I'll just make the decision. All right. I think that's how we'll do it. Okay. So you get August 7th, 2026, 12 noon. What state was he born in? Or did he come from?
Oh, San Diego.
Out in California?
I've been working on that and I've got just about everything I need, but
You may be able to go down, although it wouldn't constitute a driver's license. Washtenaw County has a program where they will issue an ID.
where do I do that?
It's through, no, it's okay. We'll look it up. I'll have my staff pull it off. We'll give you something. And that maybe make everybody's life easier.
Your Honor, just to confirm, Dale is able to sign.
Dale, him,
Yes.
he's not a party to the case. So I don't think he can sign it. And I don't think he can sign it on his behalf because he's not a conservator or guardian. He would have to sign it. And I'm a little bit worried about that happening. All right. So let's not do the judgment now. If it gets to a point that a judgment's going to be necessary to enforce it and to protect your client's interest, on the 7th, we'll figure out a way to do that, which may involve just setting a quick trial, people providing me the documents, and I just make a finding as opposed to it being a consent.
Understood.
Okay? Thank you. Guys, have a good weekend.
Which is a senior residency that's subsidized by HUD. Your Honor, you may recall we've been here several times.
Mm-hmm.
We've been trying to resolve this amicably. Unfortunately, we were under the impression that after we're here on the conditional dismissal, that those terms were going to be abided by. Particularly, there was payment terms that were required. There was staying out of a gardening area that was required. There's attending gardening meetings that was required. None of that has. You'll hear today that Mill Pond Manor is being unreasonable, trying to be the Goliath in the room. That's not the case, Your Honor. What we're trying to do is just have accountability, and that's what happened on June 2nd when non-compliance was filed. Part of that affidavit identified multiple dates that did not comply with the consent order, which included gardening beyond the limited area that he was permitted to, missing the gardening meeting without an excused absence or following up afterwards, and then also an issue of late or missed rent. I will let the court know that the rent payment has been received, and part of the issue with that rent payment was that Mill Pond Manor will receive from banks, but in order to receive direct deposits from a bank, you have to register through Mill Pond Manor's portal. That did not happen, which resulted in missed payments, and the disagreement not being an issue. Nonetheless, Your Honor, the whole purpose of this consent order was to have compliance occur. So what we're seeking, Your Honor, and the gravity and the weight of requested relief or judgment possession is not lost on us, and it's not taken lightly. And compliance with the rules and regulations.
So what are the specifics of the gardening beyond borders thing?
Your Honor, if I could direct your attention to the consent order. Your Honor, I have a copy for you.
Okay. Okay.
Your Honor, as you'll see, there is a red triangle. If you'll look around or look down this way, and that is what we were asking the court back in December to address. Brother counsel and myself had agreed that Mr. Fan would stop his gardening efforts and limit it to this little border shaded in red. That has not, and part of the conditional dismissal, Your Honor, is Mr. Fan had until April 15th to remove. Following that deadline, he should not be in anywhere other than that limited area, Your Honor, and that did not occur. In fact, it's on several occasions he was located. Every resident who does garden has to attend this gardening meeting. Notice was given, it was posted. The residents that do want to garden did appear, Mr. Fan was not. For points, this is what was agreed to, and is why we had entered into the consent order so that we have material compliance with these particular terms. And so what we're seeking is a judgment of possession, and we will want to be reasonable with the court. I'm not trying to ask the court for immediate judgment. Our client, or my client, Mill Pond Manor, has offered reasonable assistance financially, as well as social services to help locate additional housing for Mr. Fan here. At this time, Your Honor, Mill Pond Manor is not a residency or community.
So just for a little context, Mr. Fan is a 76-year-old registration. He's a lawful resident. He is all alone. He's on a handful of heart drugs. He's also got on a handful of he's also ESL. So we went without an interpreter today. We can communicate fairly well, but there is a thing there. This is HUD subsidized. And I want to just make one thing clear. You see this long, expansive garden. That was done by Mr. Fan, reclaiming just border area between this complex. It's beautiful, and it sits right on the back of Mill Pond. That was all with permission. When the prior manager left, the new manager, Mr. Riddens, revoked that permission. So this is where the struggle ensued. The garden, it's not just a garden. The MSU extension offered in the context of settlement negotiations to maintain it in perpetuity because of the rare plants that he was able to grow in there. So this is really, it's not, I'm a vegetable garden. This isn't what it is. But they weren't interested in that. In fact, there were repeated threats by management to Mr. Fan to bulldoze. We reached a compromise. They claim that those words never happened. Obviously, there's a difference of opinion. It's immaterial. The COD, because this is HUD subsidized, requires a material violation, right? And this is stuff I learned in this court, one or more repeated. I don't have to tell the court the law. I understand that. There was an initial affidavit that came with this letter on the 19th that made these allegations. And I went down and I sat for an hour in Mr. Fan's room where I have been multiple times. There's several claims in the affidavit that you just heard from counsel, and I want to address them. The first is that he failed to pay March rent. May I approach, Your Honor? No, we'll start here. To Mr. Allen, counsel has put a cover page on it. This is the first, the ledger report produced 3 weeks after the affidavit of noncompliance, showing that he owes $540 for supposedly March and May rent paid. The affidavit is simply false on that point, and frankly a little troubling. And the ledger they produce is patently contrary to the bank record showing the receipts. Mr. Martone was on my speed dial during that last case. We were talking a lot. We never heard anything about that. So I think the rent is a canard.
Well, my understanding is that's moot.
To the point, it's got to be a repeated, intentional, willful violation. This clearly wasn't. So now we turn to the garden violation. I thought I had.
No, I understand. I understand that, but.
So as to the garden, there is a video on May 12th where he walked into the larger part of the garden. There is runoff from a couple of swales to get a bucket of water to feed a rare tree fence. In fact, counsel sent me videos from the 31st that say, well, here he is out of the garden, and they clearly are him in it. That's why I think we're not seeing them on the record today. So I went down there, he's complied, he made that one trip out, he shouldn't have. He believed that he had till May 15th. Again, this is comprehension, not April 15th. He hasn't been there since, and there's no evidence it's been there since. The garden meeting, he went past at 45 minutes before, he went back at 10 minutes of, there was no one in there to go. In fact, he's willing to give up the garden. He doesn't have anywhere else to go, right? There are letter violations that counsel had the good grace on the May 19th to say, we're not worried about it, but there hasn't been one since. They claim there is, but there's no evidence. He's largely performed for 6 months, and the balance of the hardships here, they have offered him, I had not heard before just now that they offered to find him, help him find additional housing. That might be something that we would consider. He's old and frail, and he's largely performed for 6 months. I'm not sure what that unauthorized trip to the garden really harmed them in any way. We would ask that he be allowed to stay because he has nowhere to go, and he's fully gets $1,000 a month disability, or I think it's Social Security now because of his age. And he pays his rent. It's $250. I don't know how to help him, given the current housing situation and his medical condition. So for those reasons, you would ask that he remain.
Your Honor, I would just submit to the court that there has been evidence of Mr. Fan being in the restricted area of the garden on multiple occasions.
People these days are just spending all their time trying to rectify their rental obligations. It seems to me that it's the garden or there's some other issue, but somebody may be saying, if he's willing to give up the garden, then I don't have an issue, do I?
Your Honor, I fear that we're going to be right back in here because he's going to be gardening again.
And when you grace my doors, I'll say welcome.
There's been multiple issues with Mr. Fan's tenancy. When we were here in December and agreed to enter into the consent judgment, there were also other issues about health code violations or keeping his place tidy, having those. There was a physical altercation a couple of years ago between Mr. Fan and Mr. Ridings. And there's been a pattern of issues that has escalated to this point. We had the consent judgment, which said he will not do these matters. I can't speak to because I don't know who the prior manager was, Your Honor.
But it sounds to me like he didn't have problems with the prior manager.
Your Honor, that's not my understanding.
There hasn't been a case until these, Your Honor. There was a non-payment case that Ms. Kim from Legal Services did, and the repeated refusal to provide Mr. Fan with a ledger. And as to these other things, Your Honor, none of them were pled in the complaint. None of them were part of these things. We're going back to ancient history. Like, I just don't think it's proper.
Well, but one is the rent. That's been resolved. The other issue is the garden. And he says, I'll give it up. I just won't do it.
Your Honor, and my only response would be, because that was what was agreed to 6 months ago, that he wouldn't garden in this area.
Sounds like I'm dealing with the damn straight from her move. What do you mean what was agreed to be? I get it, but that doesn't mean that the court has to take the most harsh remedy.
And Your Honor, that's why we're asking for a reasonable transition period of not kicking them out tomorrow, but
kicking him out nonetheless. Say what it is. I mean, that's what it is. You want to evict him, but we want to do it nicely and in a gentle way.
As if we have a judgment that same terms, if he doesn't materially comply with the lease, we're not having to go through this dance over it. I mean, this is our concern of having a tenant that complies with the lease. Your Honor, for the most part, yes.
No, because that's the problem. If for the most part, that's it, or if they do it. I mean,
But if I can rephrase it, Your Honor, I would not be candid with the court if I said there hasn't been Mr. Writings having sit-down discussions with certain tenants over occupancy of their property. However, nothing has escalated to the point.
Is there a social worker present?
So, Your Honor, there was someone from so this is a national religiously oriented difficulties, I think emotionally, that helped him feel a lot better. This is company until last week when he got this call out of it.
Your Honor, respectfully, that's not an entirely accurate statement.
9 or 10 months into the litigation.
Counsel, you believe that his violation of this was intentional?
I do, Your Honor.
All right. Here's what we're gonna do. You guys want to do that? You're gonna have to put up or shut up. I need a hearing date on a Tuesday. We'll just go through we'll just go through a hearing. July 21st?
Yes, sir.
What time? 9? July 21st, 2026, 9 a.m. Bring all your witnesses, bring all your evidence. Private and assisted management versus Avery Wright.
Good afternoon, Your Honor. Sorry.
DK 0757 on behalf of the plaintiff.
Good afternoon, Your Honor. Gail Rosen on behalf of Ms. Wright.
You all right? Is Miss Wright present?
Ms. Wright's present.
Oh, there you are. Okay. I didn't see you and I saw that Michigan, so I purposely ignored it. Okay, where are we on this case?
Well, Your Honor, our office received no appearance, either request an adjournment to appear via Zoom.
Yes.
I apologize for no prior notice. Ms. Wright contacted our office recently, so I also apologize for being in a t-shirt. But Ms. Wright has scheduled appointments.
Okay. So I don't have a problem with an adjournment. Question, would you guys like the 17th or the 24th? Fridays.
The 24th would give her more time to.
I need 1 week or 2 weeks out to try to get things done. Then I will adjourn this to July 24th,
At what time, Your Honor?
2026 at 1 p.m.
And can we appear by Zoom or?
Okay, and then the Zoom paperwork, you fill it in and I'll strongly consider allowing appearance via Zoom.
Okay, thank you very much. I appreciate your time.
As long as I don't have to look at that Michigan thing, but we'll you guys talk about it.
We'll all dress differently. Thank you.
Roxanne Fritton versus Freeman Clark. There we go. Oh, as resident Zoom. Okay, what are we doing, guys?
Good
State your
afternoon,
parents.
Your Honor. Lane Spau on behalf of Roxanne Fritton.
Good afternoon, Judge David Morris, P83922 on behalf of the defendant, Mr. Freeman Clark.
I believe we have a settlement in place that will result in a conditional dismissal being filed at this point, probably Monday.
Is that correct, sir? All right. Then what I will do, I'll mark the file, it's conditionally dismissed. I'll just adjourn it out a week to the 17th, 2026 at 12 noon. You guys get that into me. We'll take it off the docket and we'll be good. Eunice Morrissey versus Zachary Kelly. Oh, joy. Can you, I did something, but I didn't. Your names?
Eunice Morrissey,
All right. And who,
it's my husband, Alan Ballman.
you want him up there with you? Your name?
Zachary Kelly.
All right, folks, there is no lease, correct? It was a month to month. Well, by law, it would be a month to month. Yeah,
He never paid any kind of
right.
any money towards living there.
What makes you think you could stay? Yeah, they sent you a notice you haven't moved.
No, they gave me more time to look for other residents.
Okay, so they showed you some grace and said, and why haven't you moved?
I still haven't found anything, and they agreed to extend my time more, and so I can find something, because I have been reaching out to a bunch of resources within Washtenaw County. I'm currently in communication with a couple of different nonprofits, but I mean, it's really hard to do it when I don't have a lot of funding to find homes. But I've been grateful with the fact that they've agreed to. But if I may, would the courts be able to provide me like a list of housing programs other than like Hawk places? They send me the same exact list. So it's literally I get
benefits. It's just something that is redundant, quite frankly. Okay, so here's going to be your issue. I can tell you right now, having dealt with housing issues for a while, is when you go into some of these programs, they're going to be looking at two things, right? One of the things is they'll help you get in. Which would be better for you? I'm going to let the retired people decide.
Let's do the 21st.
21st? All right. And I have a dismissal here. You're dismissing this case? Correct. Oh. If I'd known that, I'd have got you out of here a long time ago. Case is dismissed, sir. All right. Thank you. Bye-bye. Your name?
Ebony Johnson.
It's okay. Indicates that defendant, including costs, it would be $8,421. That defendant would have until August 10th, 2026 to pay. Right. What is today, Jill? 20th. I'm sorry. I thought it was dating my thing. All right. And ma'am, you're unrepresented by counsel. Is there any questions you have regarding this consent judgment? I'll explain to you. She's representing the other side. So do you have any questions of your own regarding that?
No, I don't.
All right. So this says that amount you're going to be able to pay by August 10th.
Yes.
Or vacate the premises. You understand that's what it says?
Yes.
All right. Again, since you're unrepresented by counsel, and counsel also probably explained this to you, you have 3 business days to think about this after my signing of this judgment. If you believe that there's some legal reason, some confusion on your part, or some misunderstanding, you'd have those 3 business days to file a motion. You understand that?
Yes.
All right.
Just for the record, Your Honor, she has multiple resources that she's expecting. She was approved for SCR and about $410. Hawk will assist her as long as she gets the balance below 3,000. There's a work program that she qualifies for, and then she got some personal resources that she's going to dive into that's going to pay the balance. And so that's going to raise 30 days. And my client is willing to work with her beyond that, outside of the scope of this court hearing.
All right, and I will sign that. I will just say this, that part of my concern, your name's not on the list regarding Hawk.
But until I get it down to 3,000, they can't approve anything.
Correct. They can't approve you, but if it doesn't, you could get that down to 3,000. You're not on that list of the monies that they have, so that 3,000 then doesn't happen until September funding. because people are just approved and they're rolling down until they get money. So understand that.
Over it without a hearing.
All right. And I know you want, all right, you want to take a default?
Well, actually, Your Honor, excuse me, a little confusing, but my notes indicate that at the last hearing that this court granted us a judgment. But
Yes.
not have an amount on there, but then require the defendant to pay into escrow $2,000 in the state day and then another $1,000. I don't believe that that was paid, but we were also ordered to bring in order of eviction.
So on June 26th, I've already ordered the escrow release to you, but I don't have your signature. I'm gonna hand you back this one. I'm gonna sign the one in the court file that's got a signature on it.